And jury selection begins today in the trial of the man accused of murdering 7 and injuring nearly 50 others during Highland Park's 4th of July parade in 2022. He is charged with 117 counts of murder and attempted murder. Attorney Karen Conti joins us now. Karen, thanks for helping us break this down. You know, the big question we have is, how do they expect to pick a jury in Lake County when so many people are aware of this case or maybe even were at the parade themselves?
This will be very difficult. And, you know, I think that what we have to understand is that a jury can be picked from people who know about the crime, who know all about the crime, who watch the news. But as long as they can put all of that pre-trial publicity aside and look at the facts and look at the law and they say they can do it, then the judge will put those people on the jury. But I agree with you. I mean, there are memorials there. If you have 48 people who were injured, 7 people died, how many people were at the parade who probably just missed being killed or injured? This spread out through the entire community. So this is going to be a task that the judge is going to be very careful in doing.
And then obviously the prosecutors are looking for the perfect juror, the defense looking for the perfect juror. 2 separate cases. What will each be looking for?
Well, prosecution is looking for people who are law-minded, follow the law, maybe people who are anti-gun, people who, are angry about crime and about gun crimes in particular. The defense, this is going to be hard. This is a hard case for the defense, to say the very least. But maybe you're going to find somebody who's maybe a little sympathetic to mental illness, or maybe sympathetic to the idea that he was raised in a family where the father helped him get a gun and maybe will be a little lenient. But again, what are we talking about here? If he is convicted, he's going to go away for life. There is no leniency here.
And it was interesting because he had a plea deal and everybody thought he was going to take this plea deal, and then as soon as they get to court for him to accept it, he looks at the witnesses in the courtroom and says, no, I'm not going to accept the plea deal, which would have put him away for life. What is the alternative in this case?
Yeah, well, I think this guy is not stable. I think this guy wants to be in control. I think he's never had control of anything except this thing that he did. And I think he's probably proud of what he did. So he wants to control everyone in the courtroom. He wants to control his lawyers. He wants a trial. And maybe he thinks he's going to get to say a message on the stand. The judge is going to allow him somehow to talk about all the things that were wrong about society. My guess is that he's not going to get to do that, but maybe he thinks he will, because there's no benefit to going to trial.
And that was that's what I was wondering. Okay, so and the evidence against him is so great. I mean, the deck is stacked here. You've got surveillance video, the weapon itself, his own statement to police. What angle does the defense take in this case?
I mean, this is hard. I mean, there's no insanity plea or insanity defense because you have to lodge that ahead of time.
Okay.
That's not part of it. So he's going to really just poke holes in the evidence. I mean, I think this is an exercise in futility. If I were his lawyer, I probably would have said to him, hey, buddy, maybe I can cut a deal where you're in a better DOC lockup place, closer to your family or closer to where you want to be, if you just plead guilty so all of these family members don't have to be re-traumatized by this horrific trial.
And then an interesting move by the judge, Karen, I want you to break this down for us lastly here, in allowing witnesses who are going to take the stand to sit in on the trial.
Normally speaking, if you're a witness, you cannot go to the trial and watch unless you've already testified. Why? Because you don't want the witness to be affected by other people's testimony and dovetail, perhaps, your testimony to theirs. But in Illinois, we have a Victims Bill of Victims Act, and that says that if you are also not just a witness, but you're also a victim, you do get to sit in as long as the judge makes the determination that it won't affect your testimony. The judge here said all of these victims who want to testify, we're going to allow them to sit in the courtroom and they're going to be able to testify. And this was a ruling that the judge made. And I think that was very good for the witnesses who want to be there and face the defendant who harmed their loved ones.
Karen, thank you so much. I expect that we'll see you more. This trial is expected to last about 4 weeks.
Thank you, Natalie.